Hi, my name is Neha Janeja and I work as a consultant for Doctors Without Borders in the area of intellectual property law. I'm going to talk about digital rights management today in this module. And would be throwing light upon the legal protection of digital rights management. The main areas of focus would be digital rights management, technological protection measures, rights management information, DMCA, the Digital Millennium Copyright Act of United States, European Information Society Directive, Indian Copyright Act, Waipo Copyright Treaty, and Waipo Performances and Phonograms Treaty, basically the Waipo Internet Treaties. Here I would talk about the evolution of the digital technology. Rapid evolution in the distribution of media in the audiovisual and literary sector is no more just limited to conventional methods of distribution. There has to be a lawful acquisition of copyrighted work as well as fair and equitable remuneration of the authors. These two aspects are very important because the authors and performers work very hard, and proper remuneration gives them hope and motivation to manage efficiently the distribution of their work as well as secure financial returns proportional to the extent of exploitation of their work at each step of distribution. What is the context of digital rights management? Digital rights management comprises of a set of technical as well as legal instruments which allow the copyright owners, phonogram producers, artists to manage the access to their works very effectively in a legal and ethical manner, establish permissible uses, terms and conditions for the use and equitable distribution of their work in the digital world. Digital rights are manifested in basically three different contexts. First is in the context of IP law, that's called the intellectual property law. Then the context of technological protection measures, in which we have to actually propose anti-circumvention rules to protect the digital technology. And then is the context of licenses and contracts. The limitations occur like in case of an e-book, no copy pasting of content can take place unless the book has been legally purchased by a person. An author can definitely put restrictions to download or transfer the book on different devices as well when it comes to exploitation of his work. So basically digital rights management is about selective exploitation of an artist or an author's work, and effectively with sufficient remuneration to him as well. A digital rights management is generally introduced in 4 different ways as suggested by the following illustration. Packaging. In case of packaging, the digital rights management encryption keys are built into the software. DRM encoded files, that is the digital rights management encoded files, are then made available to the users via web server downloads or CDs, DVDs, any external storage devices as well. License serving and license acquisition involve the authentication of access through various servers to provide access to legitimate users by providing encryption keys, as in the users are provided encryption keys when they log in or they have a code to access the needed technology or the needed document or the content of an author. So it's in the hands of the author to control the access of his information to the user in receipt of some payment or remuneration basically. and all this process is done legally. Legal protection of digital rights management. Digital rights management technologies are protected either by patents or are kept as trade secrets. That is, the authors or the performers or the phonogram producers do not expose their formulae or their writings or their innovation or their creative work to anyone, and they keep it reserved, and that is called a trade secret, or they get a patent protection on their work. It can even be in case of hardware digital rights management technology. Digital rights management technology licenses are used to establish secure transmissions from the content provider to the individual end users. So there is a contract or a license between two parties per se, between the content provider and between the end user. The clauses are designed in a way that directly serve the copyright and security interests of the content providers as well. Advantages and disadvantages of digital rights management. It enables the micropayment schemes where users pay for what they consume, in the sense that if a person wants to access one chapter from an ebook, then he can take a limited subscription as well for like a 24-hour subscription to access that content, that particular content, or he can even take a longer membership to access that content and pay a higher price. On the other hand, fair use doctrine is a major concern under digital rights management. These systems use a range of mechanisms to identify and track the activities of end users, and the drawback here is that this hinders the privacy and the rights of the end users. DRM results in a reduction in the freedom of expression as it interferes with scholarship, parody, review, speech, commentary, etc. It also causes a major stifle in the innovation, and the companies do not get the incentives to develop new technologies and interact with the copyright works. Now we are going to talk about the international treaties which govern the digital rights management system, and there are developed countries who have implemented the Waipo Internet Treaties, the World Intellectual Property Organization's Internet Treaties, called the Waipo Copyright Treaty and Waipo Phonogram Producers and Performances Treaty in their own national legislation. Waipo concluded a convention to protect the DRM systems. The formation of two treaties, Waipo Copyright Treaty and Waipo Performances and Phonogram Producers Treaty came into force on March 6, 2002 and May 20th, 2002 respectively. It was adopted uniformly by more than 100 countries, majority being the developing countries. Article 11 of the Waipo Copyright Treaty and Article 18 of the Waipo Phonogram and Phonogram Producers and Performances Treaty state that it is necessary for all the members who are signatory to these treaties to provide legal protection and legal solutions against the evasion of technological protection measures, also known as TPMs, that are used by copyright holders, performers, phonogram producers, in order to maintain the interests of the preservation of their technology. Protection against illegal activities such as hacking and unauthorized distribution of copies of copyrighted material is also known as digital piracy, which is also being protected under the legal umbrella of these treaties. Protection of rights management information, also known as RMI. Article 12 of the Waipo Copyright Treaty and Article 19 of the Waipo Performances and Phonogram Producers Treaty obligates the member states to take adequate and effective legal steps against unwarranted and unauthorized trifling of the rights management information, and also in cases of works or copies of works where it has been a tampering of the rights of the author without the knowledge or without his own knowledge. This also includes distribution and rental rights, right to receive payment for certain types of communication to the public. The main supporters of the Waipo treaties are US and Europe. These treaties came into force and have been ratified and being implemented in the different national legislatures of member states in order to protect and balance the interests of the right holders as well as the end users. Anti-counterfeiting trade agreement and their relation and how are they governing the protection of digital rights management. ACTA is creating new intellectual property enforcement standards which are more stringent than the international forums such as Waipo and World Trade Organization. These negotiations take place secretly and not in open international forums as the negotiations which take place in other international forums such as Waipo and WTO. Through this agreement, the countries aim to increase the authorities of the law enforcement agencies to prohibit digital infringement activities. This agreement was negotiated from 2007 to 2010 but was only ratified by Japan. IP enforcement provisions, that is the intellectual property enforcement provisions to protect online internet service providers by promoting blocking of content and filtering of information. ISPs are provided to block and filter the information so that only a refined or a set of information is delivered to the end user which is legal and which the authority wants to provide to the end user. This imposes criminal penalties for promoting copyright infringement. This treaty has very stringent provisions and therefore it has been rejected by Europe in 2012. United States Digital Millennium Copyright Act. The DRM provisions of the Waipo Internet Treaties were successfully implemented by US under the DMCA in the year 1998. Provisions under DMCA to protect DRM are: these clearly distinguish between the protection for technological measures that control access to work and protection for measures that control use of a work. So there's this major distinction which is clearly given in the given statutes. Access control provisions also aim to prevent preparatory activities like manufacture and distribution of tools that are primarily meant for facilitating circumvention of access control. Furthermore, anti-circumvention provisions relating to protection of usage control measures prohibit only preparatory activities. Exemption provisions are also given under the DMCA. They serve the purpose of encryption, research, law enforcement and security related government activities. Civil as well as criminal remedies are there under the statute for violation of anti-circumvention provisions. Now I would like to discuss some of the Digital Millennium Copyright Act cases. First one is the Marvel versus NCSoft. In this case, Marvel is suing NCSoft and Cryptic makers who have a massive platform, who have a huge platform of online games for copyright and trademark infringement. Marvel has claimed that because players in the games who create superhero characters to send on in-game missions can make characters that look like Wolverine or the Incredible Hulk. So basically the players who create the superheroes look like Wolverine and Incredible Hulk. So the creation which is being done through the medium of digital rights management are contributing to players' infringement. RIAA versus Charter Communication Archive. The RIAA sought to force the Missouri ISP Charter Communication to turn over the identities of its customers who the RIAA believed had engaged in peer-to-peer file sharing. All those network of devices which are connected which are connected in a single network. The different users who are connected in the network are trying to access the content, ebooks, their content and other online material via peer-to-peer file sharing, which is also prohibited, which is unethical. There are more cases. Chamberlain Group versus Skylink Technologies, fighting the abuse of copyright law to stifle competition. EFF helped Skylink score a very important victory in the Federal Circuit that puts much needed limits on the controversial anti-circumvention provision of DMCA. Chamberlain is a manufacturer of garage doors. It invoked the provision to stop Skylink from selling a universal remote that works with Chamberlain garage doors. The court rejected because these provisions were stifling the competition, noting that if it adopted company's interpretation of DMCA, it would threaten many legitimate users of software within electronic and computer products. So this was anti-competitive, something the law must aim to protect. Lexmark versus Static Control Case Archive. EFF helped defend a printer cartridge company against a competitor's overreaching copyright claims under the DMCA. Lexmark actually brought a lawsuit against Static Control in an effort to eliminate the market for remanufactured or refilled toner cartridges, because if it had not stopped them, they would be manufacturing or producing or refilling the cartridges, which would again be anti-competitive. So in order to protect their own brand for their own protection measure and to stop this piracy, they fought a case against Static Control Case Archive. Now I'm going to talk about the EU Copyright Directive, which is also known as the Information Security Directive of 2001. It was formulated with an attempt to harmonize the copyright law within the European Union. But still, the different member states implement their own national copyright laws in different languages and with certain flexible and different provisions. But they definitely try to formulate the provisions of the Information Security Directive in their own national legislation. Article 6 of the directive makes it necessary for the member states to provide adequate legal protection and solutions against the circumvention of technological protection measures, also known as TPMs. These are the provisions basically which are given to protect, which are formulated in the Information Society Directive to protect digital rights management. Furthermore, Article 7 of the directive prohibits the tampering and stifling of the rights management information, dealing in such infringed works when the person engaged in such acts as inducing, enabling or facilitating infringement of copyrights through such actions such as hacking or piracy basically. It also prohibits many activities of commercial nature with respect to circumvention of technological protection measures. The issues here with the implementation of Information Society Directive are: none of the member states have provided an express right, an exclusive right for users to circumvent the technological measures for non-infringing purposes. So basically, the interests more or less many a times lie in the balances or goes in the favor of the rights of the owner of the rights, since the copyright regime implemented by different member states is diverse in different languages with different provisions. the users of information in cases of exceptions have to reach out either to the court, that is the law enforcement agency, or the concerned authorities in the absence of the right holders of the courts. So here the issue is that the copyright provisions for different member states in the European Union are so different and diverse that if a person has to access, if a user has to access some information online, and that information is only available in a limited manner or is restricted, or if he or she wants to access that information, he has to basically first and foremost go and take the permission of either the law enforcement agencies or the copyright holder. So not in all the cases it can be possible that the end user goes up to the right holder to access even a little amount of or a limited amount of information. There are many other digital rights management provisions which are anti-progressive, and there have been serious issues raised over freedom of speech, scientific research, innovation, competition in the market, fair use, which balance the entire digital system between the interests of the right holders and the users. And now moving on to the Indian Copyright Act and how Indian Copyright Act has implemented two main provisions for digital rights management. The Copyright Act was amended in the year 2012 in order to make it compliant with the international internet treaties, that is the Waipo copyright and Waipo phonogram producers treaties. And even though India has still not ratified it, India is trying its level best to balance the interests of the copyright holders and the end users by having added Section 65A and 65B post the amendment of the Copyright Act. Under Section 65A, the Anti-Circumvention Provisions along with the exceptions are stated. The three implications are of this section, three major implications of this section are: by limiting the application of anti-circumvention provision to cases related to purposeful infringement, there is a high bar for invoking actions under this provision. That means that one can limit the application of anti-circumvention provision in cases of purposeful or intentional infringement if the circumvention was not for the purpose explicitly prohibited by copyright law. The anti-circumvention will not apply. That is, if the copyright law has not been infringed and the circumvention was not carried on intentionally or purposefully or with a wrong illegal intention to tamper the rights of the copyright holder, the anti-circumvention provision shall not apply. The circumvention is also allowed with the help of third parties if certain procedural conditions or aspects are met. Furthermore, Section 65B of the Act says, if any person intentionally removes or alters any rights management information without informing the concerned authority, he or she shall be imprisoned for up to 2 years as well as fines. There have been similar punishments for persons who distribute, make copies, indulge in piracy, that is, indulge in internet piracy, or hack the right holders or other persons' information without his or her consent and communicate it to the public, and in a way tampering the rights management information, he or she would be penalized. The provision also particularly mentions the criminal remedies are in addition to the civil remedies provided under the Copyright Act for the owners. There was a recommendation by the Standing Committee on after the amendment of the Copyright Acts. As per the experience and the situations which occurred in the developed countries and the cases which took place in the developed countries, TPM's technological protection technological protection measures had stifled innovation. It was noticed that they also limited the access to public works, fair use rights, and overall hindered the privacy of the end users. The Standing Committee therefore suggested that the Indian judiciary, the Indian copyright law, or the lawmakers should evolve the law based on practical situations on a case-by-case basis. They should not implement all the stringent provisions for all the cases in common. On a case-by-case basis, they should implement. As India is a developing country, we need to promote innovation instead of stifling it. We need to make public works accessible to the public. We need to make new and novel content by means of fair use available to the public, and also take into interests the rights of the copyright holder as well as the end user. Committee also recommended minimal legislative interference in the proposed amendment to Section 65A, and rather that there be some sort of judicial analysis if and when required to create rules and guidelines based on current trends, the latest trends, and on a case-by-case basis. Because they want to facilitate access of the works done by the copyright holders to the public in a legitimate and secure manner to balance the interests of both the parties. Moving on to the comparison of three jurisdictions, the US, European Union, and our own country, India, which is a developing country. So here the main difference lies between the fact that US and EU have a well-framed copyright law which they have been practicing for over a decade now, for over 2 decades in fact. DRM provisions in India are less extensive and, as we discussed, implemented on a case-by-case basis with least intervention of the judiciary in cases where it's not required when compared to DMCA and Information Security Directive of Europe, which are far more reformed. The DRM provisions in the United States and European Union have been in existence for a decade now, and so lay an effective platform for others also to learn and follow. The absence of terms like technological measure create a gap while interpreting the Indian law. So this is a drawback as to whether the provision relates to access control measures or copy control measures, or both per se. So there is definitely a gap in the law, in the Indian law, when it comes to the terminology, which is more explicitly given in the Information Security Directive of Europe or Digital Millennium Copyright Act of America. It does not appropriately differentiate between effective technological measure and non-effective technological measure as well. I would conclude by saying that DRM is theoretically introduced to help copyright owners by protecting digital content from illegal copying or distribution. It is still very contentious to say that since DRM imposes restrictions, it might impose certain restrictions on legal users and might hinder innovation and free flow of information, especially for growing economy like India. On one hand, it is protecting the rights of the copyright owners by protecting their contents from getting illegally copied or their contents being infringed. it is still very contentious, it is still very disputed, that even though these factors are very important, DRM is still stifling competition, is still stifling the use of public works, fair use, and it's still imposing many such commercial restrictions on the legal users, which would otherwise be benefit for the larger good of the public, and especially for a growing economy like India. A comparative analysis of EU, US, and Indian copyright regime shows that even though India has tried to implement the provisions of the international internet treaties to a certain extent, there are still many gaps in the case laws which make the interpretation of law very complicated. Fairly complicated. It does make the law complicated because there are certain technical terms which are not explicitly distinguished, which are not explicitly given in the legal text, in the provisions. So India needs to still work upon harder on the amendment of its Copyright Act, but at the same time it has a duty to maintain and balance the interests of both the end users and copyright producers. Thank you.